right about now, we want to go to the corridors of justice, basically just to have a very difficult but very necessary conversation on students' welfare while they are in schools, and of course the thin line between parental and institutional responsibility and the increasing concerns around supervision, suspension, discipline, and everything in between. And to help me with this conversation this morning, we have Peter Wasaga, an advocate of the High Court of Kenya, just to talk about students' supervision. What do you need to know and where's the line? Karibu sana Peter to TV47.
Thank you so much.
Yes. You mentioned this is not your first time, but it's your first time with me, so I'm very, very happy to host you.
Thank you.
But I want us to start with this. What does the law actually say, about the duty of care that schools owe to students while, in the school's ground?
Thank you so much for having me in the show. This is a very pertinent issue, and which has, in many occasions, led to interdiction of many teachers, loss of lives, loss of dignity, and for students, and sometimes it leads them to drop out of schools because of how they are treated. One thing is very clear: the Constitution being the grand norm that regulates how we should interact and treat each other, under Article 53, guarantees that in every matter concerning a child, the child's best interest is of paramount. So that whenever you are interacting with a child, with a student at school, you must ensure that this clicks. And whenever a student is suspended from school, this must be taken into consideration. Whenever punishment is administered to a student, this must be taken into consideration. Whenever a student is released to go home, could be is released to go and fetch fees, maybe suspension or expulsion, the best interest of a child must be of paramount. And that is something that, one, it should be well informed. The teachers should be well informed. There should be policies that should guide it. But most importantly, there should be adherence to already existing policies. So there are so many responsibilities. But first, we must appreciate that the primary responsibility lies with the parents. The parent has the greater degree of responsibility over a child, provided that child is not 18 years. I mean, of course, he is no longer a child at that point. And when a child or a student is out of the parent's responsibility and care, this is donated to the teachers. And the teachers should ensure that they take up this responsibility up to until the child is properly handed over to the parents or guardian. And the handing over should be well structured. It should be a physical handover or through recognized channels of communication. And when a communication is made, it should be sent in it should be sent in a proper way, non-contacts and acceptable channels. Of course, the law has evolved over time. When a student gets to school, normally you'll take their contact details, contacts of the parent and the guardian. The acceptable channels, even if you look at the civil procedure rules of service, there is the WhatsApp. You can text them on WhatsApp, you can do a letter, you can call them. Of course, there is a chain of command. You'll be asking, how then would a principal call all the parents? Because in a school, for example, where I was in Bita High School, of about 1,000 students. Now, these 1,000 students, you don't expect the principal to call each and every parent, but there is a hierarchy. From the principal, there is a deputy principal, there is the boarding master, and you go down to the class masters. And the class masters are responsible for each and every parent. In fact, with the digitization, normally, nowadays, there is even a WhatsApp group. During our time, there was no such thing. We would go to school and you will be released to go home, with or without fare. The phone calls were rare. Because I think for at least for me, it was during that time that mobile phones were being introduced in that area. So even reaching out to your parent will be very difficult. But now it's very easy. You can easily reach out to the parents, notify them that the children are closing for half term, the children are closing for holidays, then what is expected of them. When a child is suspended, it means that, or expelled, it means that they are released out of school under very special circumstances. And during this time, this child, in one way or the other, he is disturbed. So he is a child that is under need of protection. He is in their need of protection, both from the school and from the parents, because he could be afraid of the consequences of his actions at school, and may not even the accident, but he could even decide to go elsewhere and not even to go home. So then who has that responsibility?
Yes.
It's very important that you notify when there is a disciplinary case in school. Parents should be notified. There should be a proper suspension letter entailing every details of the offense that the child has committed, the conditions of that suspension, the duration of that suspension, and then the parents must be notified to come and pick their child, or even if the parent has not cannot come to pick their child, there should be proper arrangements. Okay. And when the notification is acknowledged, then that absolves the school from that responsibility in case of any breach.
All right, Wakili, you've talked about Constitution under Article 53, of course, which affirms the child's right to safety, dignity, and education in a secure environment. But why do we keep hearing cases, of where children suffer harm and some even die in the school compounds, but no legal action is taken? I know you've talked about some teachers being interdicted, but we don't really see much of this happening. We hear about students being assaulted while in the school grounds, like I've said, some even dying, some outing themselves. But why don't why does the law treat this casually?
Thank you so much. One, we have everyone to blame. You see, an action cannot arise from a vacuum. An action must be instituted. So when there is a duty of care, for example, when you look at the law of torts, it clearly spells out some of the elements of the tort of negligence. Like in this case, what happened last week, where a student was allegedly suspended from school. The parents were not notified of the suspension. In the midst of all this confusion, the child gets involved in an accident and he dies. So you tend to ask, who had the duty of care? Of course, when you look at the tort of negligence, you look at the duty of care, the breach of duty of care, where there was a foreseeable harm, and of course, there is the consequential damages. So foreseeable harm here is when you release a student from school without proper communication, obviously with regards to what I said initially, that this is a child that is scared of the consequences of his action. He can easily, because of panic, disappear or just get lost, you know what I mean? And so it's important that he can even commit suicide. You've seen all those, the depression and mental health issues which really come with such actions. So it's important that when such cases arise, we should, one, understand the elements of tort, of negligence. There was a duty of care, there was a breach of it. The teachers did not use the proper channels to communicate to the students, and there was a consequential loss. So with that, an advocate or a parent must now proceed to institute a legal action, maybe through an advocate, by doing a demand letter and matter being taken to court. But if you do not prosecute it, it disappears, looks like an accident case. You find in so many cases, they ignore. They say that, okay, so long as I have come out safely, I don't need to pursue this blood money. That is the reasoning that is in the village. I've seen that even with people who are very close to me. When you advise them that there is an insurance and there is an accident that has occurred, there was negligence. So you should take an action so that you get compensated. So most of them it's because of ignorance, but it's because of frustration. There is a way the school shields shields the perpetrators of these heinous acts. No one is willing to take up the responsibility. So I feel that one of the recommendations we should have is very clear policies on how on the reducible minimums in case of any suspension or expulsion or the duty of care of students when they are in school, so that we are able to refer to that policy. That this policy can be drafted by the TSC. It can be implemented by the government, so that it can be implemented by the executive, so that at least we take action. And when you take an action against one individual, then it becomes a lesson to the rest, because law, part of the reasons that law exists is for purposes of deterrence. So if you deter one, if you punish one, it will deter the others. The other thing that really is of an issue is because of maybe lack of capital, money to maybe instruct an advocate. That could be also an issue. Then, of course, cover-ups. There are cover-ups all over. And all these things. You see, there are so many parents who've been following up on their cases of their children, and no one is willing to take up the responsibility. Look at how the criminal aspect of it has taken shape. Long ago, before the enactment of the Sexual Offences Act, and maybe the TSC having to tighten their code of conduct of teachers. Normally, in the recent past, a teacher would defile a pupil, get pregnant, or even marry her, and nothing would be done. But now, because there is the Sexual Offences Act, with or without consent, a teacher will be punished for having sex or sexual intercourse with any student or a child who is below, any person below the age of 18. So apart from it being a criminal offense under the Sexual Offences Act, it has also repercussions under the Teachers' Code of Conduct, which will lead to interdiction. In very rare occasions, there will be suspension and later reinstatement, but mostly it's interdiction.
All right. Who should then take accountability when a student is harmed while in the school grounds? Is it the head teacher, the principal? We also have the board of management, or the ministry, or even the parent. In case of this, the example we are using of the student who died last week, after being sent home, of course. But now who is to be held accountable exactly?
Looking at Section 29 and Section 31 of the Basic Education Act, it clearly stipulates the roles of various stakeholders in the school. One of such stakeholders is the head of institution. He is responsible for the welfare of the learners while they are at school. The other person, the other body that is mandated also to take up that role is the board of management. So the first person to go after is the head of institution. The other person to go after is the board of management. Then, of course, depending on the nature of the crime, there are certain crimes that involve, you see, for example, criminal matters are individualistic in nature. So that whereas civil will go for the head of institution and also the board of management, for criminal, it will take each and every person must take his or her responsibility and bear the consequences of his or her actions. But that notwithstanding, you see, there are things that also really warrants a lot of sanctions. For example, leave alone the fact that sometimes students get suspended, expelled, and there is a breach of duty of care. But there are instances where these children are betrayed by the same people who they have been entrusted to give them protection. Harassment, for example, corporal punishment, though it has been outlawed, it's still going on. Students are being embarrassed. Some of their confidential information are being released out here. For example, a student or a pupil comes to your office for guidance and counseling. Following there, I was in one of the institutions where you had gone for a weekend challenge. You see, students are complaining that I cannot go to a specific teacher who is actually in charge of guidance and counseling, because when I do that, they are the same people who will take up that information and tell the other teachers. So all the other teachers look at me as maybe a girl who has done abortion for 6 times or 7 times. They look at me differently. So these are some of the things that must also be dealt with.
Yeah.
Some of these things, the teachers are very ignorant, and they must be called out, they must be told, and in the very, very punitive manner, they must be punished for it.
So we often, in such cases where maybe a student has been harmed in school or even dies, we often hear these school heads saying that we inform the parents. Of course, as you say, communication is important to the parents, but does informing the parents exempt the school from taking responsibility of what has happened to the student?
Now, the information part of it, how is it done? Because you see, again, it will be very difficult, because it's assumed that once I inform you, you should make arrangements on how your child will reach home. So long as the information has been passed through the right channels. You know, teachers cannot organize for each and every student to take 1,000 students to their respective homes. I cannot take maybe Wasaga to Suba, and I take so and so to. My responsibility ends at that point, that I have passed the information, and you know, I mean, there is proper communication channel. The information has been, so there is the communication, there is the deliverance of that communication. Has it been delivered, or you used a student's phone to communicate to a parent? It must be through acceptable channels. Number 2, acknowledgement. Then number 3, handing over. So how do you hand over? At that point, it's assumed, it's presumed that when the right communication is done, then the parents should organize for proper proper picking up of their children from school, and that should also absolve teachers from the gate going forward, provided that it's not their arranged transport. For instance, there are instances where the school has arranged for transport. For example, there's a school bus. With that, the duty squarely lies on you until the child is properly handed over to a respective pick-up point. It could be also during co-curriculum activities. It's outside the gate, but you are still representing the school. So the duty of care still lies on you. It could be maybe on tours. The duty of care still lies on you. But I think there should be a differentiation. The duty of care will only be breached if there are no proper communication channel from where I stand.
Yeah. So in a case where you see you've informed the parents, but now the parent now calls you back to say, maybe this was late, but we cannot now take the child back home. Maybe he or she can stay in school, but now the school refuses to host the student again. Then something happens to that child. What happens in that case?
Thank you so much. When and how you release the student also really matters. You cannot communicate to a parent to come and pick their child at 12. There are acceptable timelines upon which a student should be released from school. And there is no harm in this child staying in school, provided there is also proper communication of the same. I would write a letter that, yes, I confirm receipt of your suspension of my child, and my notification that I pick my child or organize for the transport. But at this time, I am not in a position to kindly hold the student at school until I'm able to. So it should also be a reasonable time frame. It should be a reasonable time frame. You should not just release a student wielding you up. That's an abuse of power. It's an abuse of power. And sometimes it's because of lack of understanding, lack of empathy, lack of being a parent. And you see, when you treat a child, someone's child, you should treat that child the same way you would expect your child to be treated. You cannot just come and suspend a student at 4. And this student, you expect him to go to come from all the way from Bita or Homa Bay to Nairobi. That's being very unreasonable. And that, so long as you can prove that there was negligence on the part of the teachers, that is something that is actionable.
So in case that happens now, what recourse do these parents have, just or maybe against the school, to say that, you know, we communicated, I told them that I couldn't pick my child at this particular point? Then how do parents now approach that particular situation?
Again, even before I answer that question, you know, one, in this scenario, I'm told that it's alleged from what I read in the media. It was a post of one, I think I saw it on Facebook, that the parent was not notified of the child's alleged suspension. And the parent only discovered that his son was out. So there was a breach already because he was not notified of the suspension. He was not notified of the release. He only learned it when the child was already out. So that was already a breach. The second breach is that this parent communicates to the teachers, and we would want to know which teacher. Was it the class teacher? Was it the principal? Was it the head teacher? Of course, we expect that the channel of communication should reach the head teacher and the board of management. That is what that's why when there is a problem with Kenya, we will always blame the president. We will always blame the minister of interior. So the head teacher bears that responsibility. So when that parent communicated, it was up to the teachers to now organize and have this child protected, because like I said in my opening statement, that in every matter that concerns a child, the best interests are of paramount. It is in the best interest that he be kept from every scavengers out there. It's in the best interest of the child that he be protected from every harm. And this duty lies with the teachers when the child has not been properly handed over to the parent. And the role is assumed by the parent upon proper handover. So in this case, I still believe that there is a course of action that can be channeled through the courts, and the school should be sued for that. The board of management should be sued, and we can even get it to a point of even suing the person who actioned the suspension. Because who actions the suspension? Sometimes it's not even the principal. It could be the deputy principal. There is a chain of command, and it is going through to the class teacher. Let me tell you a scenario when we were in school, and most of the experiences we had. When a student, for instance, had been found to have violated a school rule, he will be suspended, and during the suspension, this student will be made to carry his box. Will be made to carry his mattress. It would be like a suspension, and that was to deter other students from also behaving the same way this student behaved. Just imagine carrying your mattress, carrying your box. Like expulsion. It's like expulsion. Okay. That is very extreme. And the teachers should know, the institutions should know that when they are suspending the students, the suspension in itself is enough. You should not humiliate this child more by making him carry his box. It's inconveniencing. That's not expulsion, it's suspension. It's a temporary leave from school so that you are able to rectify whatever happened. But if I was given a chance, I would scrap off suspension. Because students they need just to be. There are ways through which you can punish this student.
So what are the procedures, of coming up with the suspension for the board of management or the teachers to sit down and say, now we have to suspend the student for 1, 2, 3? What is the procedure that should be taken?
It varies from school to school, but what should be done is that the board of management, whereby the head of institution is the secretary, should be aware of a suspension. But this normally does not happen. I hope you know that. It's basically maybe a boarding master and a school deputy who will just come, and because of one reason or the other, or maybe there was a squabble between the student and the prefects, the student will be called to the office, and maybe a student is found cheating in an exam. You can cancel that student's exam and leave the student to proceed with the learning. And what's wrong with that? Of course, after that, the procedure should be, once this is done, there should be a suspension letter. A suspension letter should clearly outline the reasons as to why this child is suspended. We are suspending so-and-so for jumping through the fence on this particular day. It's against this and this and this. That is number one. Condition, the suspension is for how many days? Let's say 2 weeks. Then conditions on return. One, you should return with your parent, or you should return with this and this and this for the disciplinary action. Because you see, sometimes it's done without even these students being given the right to be heard, which is against the rules of natural justice. Student will be found maybe perhaps talking in class and you are a noisemaker. It's an abuse of office. It's an abuse of process. It's something that should be called should be called out, and it should be to the extreme where maybe a student poses a threat to the other students. Otherwise, there should be other ways through which this child should be chastised and kept in school. Because the right, one of those rights is that it should have adequate time to get quality education. When you suspend this child for 2 weeks for something that he could be punished in another way, you are going to waste his 2 weeks, or you are going to waste his 1 month. You expect this child to catch up with their syllabus and everything. Then when this student fails, you also suspend him for poor performance, or even I don't know. This is not what nowadays happens, but it used to happen that if you were in number last for some times, you'll be expelled or told to look for another school. So which school will tolerate your rejects? So those are things that are outdated, and the right to education is not measured by your sharpness. Everyone has that right to get basic education. And that is something that is enshrined in the Constitution. And it is a public school, not a private school, that you suspend students for all and this. So these are things that must be taught to. I mean, there should be a training to the heads of institution. There should be a training to the heads of department. There should be a training to the class teachers. And they should let the students be protected as the law requires.
Now that you talk about the challenge that maybe these expelled students have in accessing other schools, in a case where, you know, a school refuses to admit an expelled student, then what does the law say about that? Is that student protected by the law? Can they now sue the school that, you know, can they sue the school, either the one that refuses to accept them or the one that expelled them?
It's on a balance, like I said. You see, there are certain valid reasons for having a student expelled from school. But these things are, with the time, they are diversifying. Because what used to be an offense initially, today it's not an offense. For example, if you would be found with a mobile phone in school, during our time, I know, you know, you will be suspended. But nowadays, the students are allowed to have, in some schools, they are allowed to have phones.
Some are still suspending students.
Some are still suspending students. So you look at so many things, and initially some of us will be suspended for not mopping, not doing manual work. And so it depends on the gravity. Some would be suspended because of posing threat to other students. For example, killing. That's a criminal offense. That one, even if it were you, that is a child who needs protection and care, maybe in a Boston institution. So there are institutions that are well equipped to take care of such unruly students who actually they need care and protection. But expelling a student because of something that can be rectified, something that there could be another way of addressing it.
Say this case of, you know, because of their academic performance, they're doing poorly, because it still happens. There's schools that still expel students if they're not doing well in school. So are they protected? Can the students sue?
Exactly. They should actually not even sue, lodge a complaint with the Teacher Service Commission. They should lodge a complaint with the body that is mandated to regulate institutions. They should lodge even a complaint in court, because that is not a reason to suspend a student. Why does a student come to school? I could argue it that this student is not performing because of poor teaching. So there is a problem with the teacher somewhere. So if you want to have the blame will be distributed equally. Maybe a teacher not, because you could find that this student perhaps is performing well in history and is not performing in mathematics. So is there is the child a danda? He is not. It's because there are people, I mean, students are created different, and that's why sometimes I applaud the CBC, because it's not so much pegged on performance. It's pegged on what you know, what you can do, your skills, and it sharpens it. There are those who are not very bright in school, but they have come out to be very successful in life. And so that alone, the poor performance alone, should warrant a performance improvement plan through the school, even at your workstation. Let me just divert a bit. There is a procedure that should be put to suspend you for poor performance. It should be put on a performance improvement plan. There should be a duration through which you are expected to improve, and failure of which, once everything is followed, you could be suspended, because now you are interfering with the you are not giving out. But now the other one is totally different from this aspect of employment, because we want you to get a reasonable grade that will place you, one, in a polytechnic. Not everyone will go to the university. One will place you to the university, and some will take you to the teachers training college. Some will want you to be a doctor. Some will just, there are others who just want those certificates to do other courses. They want just that certificate to apply for other things. So you do not expect to use the same yardstick for every student. So for me, I believe that is very wrong, and teachers should be called out, institutions should be called out on that, and any student who is suspended on grounds of poor performance should seek redress in the right institutions and even in the court.
All right, but we hear of disciplinary committees. Most of the time, they lack, independent child advocates. So, shouldn't they be there just to also neutralize these disciplinary committees, these independent child's advocates?
That can work, but again, we are looking at capacity. And the number of institutions, how many. You see, there are certain things that should not even be stretched to that extent. There are things that, as a reasonable parent, you don't chase your child from your house for leaking sugar. You can cane slightly to correct. You don't need an advocate to come and stand in for that child. So that they argue out their case that I took this sugar because I was feeling this and this. No, you don't need that. There are some of the things, because you as a teacher, you've been given a higher responsibility, a higher call. That is why we have entrusted you with that child. We expect you to be reasonable. We expect you to treat this child as though he is or she is your child. And the manner in which you administer punishment should also be commensurate to the crime, or let's not call them to the crime, but to the offense that this particular student has committed, so that we do not overcomplicate it. But in serious matters, where there is a threat of life, then we can have the advocates to come in, the child advocates to come in and just to try to mitigate. Because in this case, this child is also is in need of care and protection. No wonder these children, even in prisons, they are not mixed with adult criminals. There is a special cell for them, so that you don't harden them, because you could think that you are suspending or punishing them, but in the process you harden them, so that a child grows up with a lot of retaliation in mind, in heart. A child grows up with a lot of enmity. A child grows up with a lot of resentment, and before you know it, we are building a generation of people who are very hurt, and they can stop at nothing to get, in quotes, justice, which could have been treated and in otherwise a very civilized manner.
Now, Wakili Kule, corridors of justice, maybe how often is due process followed, by these teachers or institutions before just coming up with a disciplinary action against a student, especially when you're talking about expulsion or even suspension? Are due process being followed by the schools?
Rare. They rarely follow the due process. Normally, it's. I think we should just remove the traditional thinking from through very thorough trainings and policies. So one, there are no policies. And if there exist policies, they have a lot of gaps. So the first thing that should be done is that there should be clear policies on what should be done before a student is suspended or expelled. A notification of the offense, the parent is notified of this offense, both the parent and the student, so that they know that there is a disciplinary case going on in school. Then after that, a child should be allowed to come with a witness. That's my suggestion. A witness to just testify, to just oversee or to witness, that's the best word, witness on how the process is carried out. And then after that, there should be a proper communication of that offense. And then number 3, there should also be a warning. For example, you should not just rush to expel a student without first issuing this child with a warning, issuing this child with maybe, it could be first warning, second warning, suspension, then later expulsion. But there are instances where a teacher will just wake up because of an information. Of course, you see, long ago there were very, very harsh punishment from the prefects. You saw what happened in Maseno. Sometimes it was a very big case, and may Marehemu, the late principal, rest in peace, because of the corporal punishment that the students administered, the student prefects administered. So you see, this student who should actually be against these students in a case, they are the reporting students, they are the prosecuting students, and normally the teachers will side with them. And after this siding, a student will not even be given time to explain. In worst scenarios, a student will be called, marched to the office, beaten thoroughly, and suspended. And after suspension, he is expected to come back with barbed wires. In certain instances, I remember there's a school, they were told to come up with a bull, to come back with a bull or several kgs of meat, because this particular students went for what we used to call in school ndeko. This is an addition. These are hungry students. This is a student who should be taken care of. Of course, it's wrong to take an addition before others, but that is not something that should warrant a student to be suspended and be told to come with 10 kgs of meat.
Bull. In that case, let's talk about that bull. Now, when the student fails to bring it back, now can they also take legal action against the school for telling them to come back with, a bull over, just pieces of meat?
Because it's not commensurate. It's not commensurate to the offense that is committed.
All right.
That can be challenged, actually.
So we've also seen cases where, students come back from holidays, and earlier this year we saw a school where students were locked outside at night because of school fees. So can a school legally deny students entry, because of unpaid fees or maybe pending disciplinary issues?
That's so unfortunate. What happened was so unfortunate because some of these students had traveled all the way from Nairobi. I'm using Nairobi because of the proximity, the centrality of Nairobi and the schools in our counties. I don't remember which school it was, but these students, assuming they travel from Nairobi and get to school at 6, then you lock them out because they have not paid school fees. What do you expect, even if it were you? It's an abuse of, as much as you could be having a point, I would insist on this, as much as you have a point, as much as there are school arrears, as much as there is an offense that has been committed by this student, just understand that the Constitution of Kenya is the grand norm, and it binds every state organ, including the school, including the president, including the head of institution, including the BOG, including the gate man who is mandated to keep security. So that the best interest will dictate that this child has come. Let her be protected, or let him be protected in school for the night. Then have a communication. For example, if there was a previous communication, make a follow-up that we refer to the above matter and our previous letter asking for the clearance of the school fee. We note that your child has not completed this fee as advised. Kindly arrange for the same. Or if that is not done within this duration, we shall be releasing this child on this particular day. It still goes back to the communication. Yeah. It still goes back to the duty of care, the protection of this child, the best interest. So that warranted, I think the teacher was interdicted.
She was.
She was. That was a very good one.
So there's also a lot of gray areas when it comes to boarding school. So from what you said, do you think that, Kenyan boarding schools take full parental responsibilities when it comes to just taking care of these kids while they are in the school grounds?
Exactly. That is a mandated responsibility. It's a donated responsibility. The moment this child steps out and gets into the gates of the school, the responsibility lies squarely with the school.
Are our schools doing it right?
They are not. Because sometimes you find there are students who are sick. They don't even notify the parents. Students die in sick bays, and they can't account for it. So as I said earlier, that when you are given a mandate, when you are given a responsibility, you are expected to act. Not acting just averagely or below average, but acting properly, acting in a manner that befits that position. So one is that this student is required to be protected, and not as a matter of just doing you a favor, but as a matter of rights under the Constitution. So yes, they have not done it. There have been a lot of loopholes here and there. There have been a lot of hues and cries here and there. But I think it's something that can be improved. And there was a recommendation that we do away with the boarding schools sometimes back. Because if you cannot match that responsibility, then it's better you take this child just within a duration that you can and release this child back to the parents. Yes, but I believe that as much as the school is doing that, the broader responsibility lies with the government through the Ministry of Education, through the Teacher Service Commission, to ensure that they are, under Article 237, the students are well equipped, they are well protected, and they are getting quality education.
We've also heard of cases where students go missing, in school grounds, and it takes hours or even days to report about it. So what is the legal reporting framework for missing students in school compounds?
Thank you so much. The first thing, notify the parent. Second thing, report to the police, get an OB. So that, because when someone is lost for 24 hours, that should be reported. That's a case. Within for 24 hours, you should report that the so-and-so is missing, so that the police are aware, they are doing investigation, the parent is aware, they are doing investigation, the school is also aware, excuse me, they are doing investigation. So that you are not just exposing yourself. Some of these things the teachers do not know. They want to manage it by themselves, which in turn embarrasses them. So it's very important that they notify these parents. This will really reduce their culpability and also the responsibility that comes with that.
So what legal action can maybe, sorry for that, can these parents take in case maybe they feel that the school delayed in reporting a case where a child was missing? What can these parents do in that case?
Again, just following the legal procedure, lodging a complaint with the relevant stakeholders, reporting to the police, excuse me, and also looking at the implications. What we see, sometimes a child could be lost. And this is a disciplinary action. A child is lost, perhaps he jumped out of the fence, went to maybe some, you should be responsible for this child. So by just communicating well and properly, then that will absolve you. Like I said, it will absolve you from so many questions because you Of course, there will be questions, how did this student escape from school under your watch? Those are some of the questions that will be there. But if you leave it to the point of, apart from the communication aspect, you have also, apart from the escaping aspect, you have also not communicated, it complicates the whole issue.
You also talked about psychological torture that maybe, these disciplinary issues can bring on the child. But, what does the law, how does the law place the mental health, burden? Is it on the teachers or on the ministry? Who really is responsible to ensure that the child's mental health is well taken care of while in the school grounds?
Thank you. That's a very, very broad topic. Because mental health, it's mental. And sometimes it's very difficult to dig in. That's why in schools there are departments that are mandated to give guidance and counseling. But guidance and counseling, it's like a hospital. The all school framework has figured it out that there is a guidance and counseling for every kind of scenario. But like a hospital, you can only go and explain to the doctor what you are suffering from. And out of it, the doctor will give a prescription. But we find that some of these things are deeply rooted and things that have been taken from home. Maybe a family dispute, maybe a domestic matter, maybe a problem with the parent, and getting to school, it may not really be solved. It may not really come out very well. So it's something that is spread out. The parents have a responsibility, the teachers have a responsibility, the chaplain of the school has a responsibility. So it's more of a spiritual and a psychological matter. And you cannot maybe blame a teacher for a child who, because of a mental issue, has decided to, provided that it is not caused by the teacher.
All right. Wakili, as we wind up, of course, what advice would you have to parents who are now watching and, just how they should be aware of their children's well-being while they are in school compounds, and of course, just to protect their kids from, death. We're seeing missing cases, even mental and psychological torture. So what should parents know?
One, the parents should know that, number one, the duty of care primarily is theirs. They should follow up on the welfare of their child. That is number one. Number two, the parents should know that while the child is at school, the responsibility of the child, the supervision, is with the institution. And the institution is required by law to properly maintain a communication system that will enhance or that will bridge that donated responsibility. So that in case of anything in school, whether be it sickness, be it an occurrence, suspension, expulsion, release of these students on half-term or holidays, the parents should be notified properly. And when they are notified, they should also know that they should also take steps to go and arrange for the children's pickup, to arrange for the children's welfare. If a child is sick, maybe if a child has a condition, they should arrange very well to go and also pick this child. Number three, the parents also have a responsibility to notify the school of any underlying condition of a child so that it is well documented that if something happens, then there are emergency things. I mean, there are certain emergencies that parents should act very fast. So if there is a well-maintained communication channel, then it means that in case of such emergencies, the parents are well equipped to respond with the urgency that it deserves.
All right. That is Wakili Peter Wasaga talking to us about student supervision, the line between school versus parent responsibility, of course, while the students are in the school grounds. Thank you so much, Wakili, for making time for us this morning.
Welcome.
All right, that brings us to the end of this conversation and to the end of the show. Thank you so much for watching. Good morning. My name is Anne Odida.